Three overarching topics we're going to, if we get through it, would discuss. First are bylaws. There are 7 topics that really are not optional, that need to be clear in your bylaws. We're going to cover some of those, or if not all of those. Then I've got a few slides on sexual abuse and some weak spots in most Baptist churches when it comes to preventing sexual abuse or weaknesses through which abuse can sometimes infiltrate. And then lastly, biblical dispute resolution in the church. It's a way to create a system that keeps you out of a secular court, but still gets to resolve disputes that do arise from time to time in Baptist churches. Okay, that's the 10,000-foot view, so we're getting ready to dive in. All right, the reality is that, oh, by the way, a warning, I don't think I can talk if I don't walk. And so you see the room is set up with a runway around the outside. I'm going to be using that runway and the part in the back because that's the only part not on camera. I guess I should have warned you, you're on camera. And so just heads up, if I come and walk around, it's not because I'm trying to get up close and personal. It's just that I can't talk if I don't do that. Exactly. That's exactly right. So kingdom work and ministry is what we're called to do. However, it doesn't come without risks, legal and otherwise. In fact, and I'm not going to read all night, but this is crucial. The areas of highest need and effectiveness are also the areas of highest legal risk in ministry. That's just an inescapable fact. Who knows what the highest risk ministry in your church is? Anybody? Youth and children. Okay. That also is what? The area where you see the highest return for our ministry investment. The stats are abundantly clear. Far more people come to Christ as young children and teens than as adults. Okay. But that's also the area that is by far and away the most risky. So what's the response? A lot of churches just do that, throw their hands up and scream and don't know what to do. That's why you're here, okay? We don't have to panic, but we do need to be proactive, okay? I get this less than I used to, but a lot of times when I would suggest, years ago when I would suggest legal steps to help protect ministries, people would just go, oh no, we've done this way for 50 years. We don't need to change, okay? Well, you may have done that way for 50 years and you may have been very blessed not to have a problem. But one thing that has changed in the 50 years is our society, the people coming onto our campus, okay? And frankly, the people that are members of our church. 30 years ago, they would have had a serious problem. They would have had pause to sue their own church. That's no longer the case. My experience is now, you're more likely to get sued by a member than you are a non-member, just because they're there far more often. It's a sad commentary, but that's the way it is. And so that's why it's important for us to take steps that we can as churches to protect ourselves and not just hope for the best, okay? I'm always a fan of being proactive, seeking out areas of weakness. One of the best ways that we can do that is to look at our governing documents. Everybody understand we have 3 governing documents: Articles of Incorporation, Constitution, and Bylaws. 2 of those are required by law, 1 is not. The Constitution is something that historically Baptist churches have used, but it is not legally required. Okay, you're only legally required to have Articles of Incorporation, because without those, you wouldn't be a corporate church. Theoretically, you could be an unincorporated church, but those are very few and far between these days. But secondly, if you are an incorporated church, you are legally required to have bylaws. Okay, what's in those bylaws can vary, but you must have a set of bylaws. That's a legal requirement via Chapter 617. Okay. Here are some common things that I still shockingly get a lot. Somebody will call me, ask me a question. What do we do? Here's the situation. What do we do? Almost invariably, my first response is, okay, well, what do your bylaws say? Okay, because the answer could be very different based on different bylaws. Well, a lot of times, if there's a long pause after I ask that question, I know we're in trouble. Okay, a lot of times they don't even know where they are. Okay. They know where they are, but they're 10, 20 years old. And usually if that's the case, this is also the case. Okay. If you've gone 10, 20, 30 years without amending your bylaws, I guarantee you there's at least one, if not a myriad of procedural steps that are laid out in your bylaws that you no longer follow. Okay. Who knows what happens if your church does something that's contrary to its own bylaws? Anybody know what that is? Or what happens? It's a repentance. Well, aside from repenting, yes. Well, nothing unless somebody challenges it. Okay, because technically, if your bylaws say go to this intersection and turn left, and the church voted unanimously to go to the intersection and turn right, that's what's called a legal nullity. You can do it, but if someone challenges it, they win because you legally lack the authority to violate your own bylaws. That's why whenever a church has a issue when it comes to bylaw problems, you've always got two options. You can change your conduct to match your bylaws, or you can change your bylaws to match your desired conduct. But leaving your bylaws one way and doing another, that's just not a valid option, not a legal one anyway. Okay? Here's some common traps, and we're going to use hypotheticals that may or may not be based in real life to communicate them, okay? The church is riding a wave of excitement about a sudden explosion in new members, most of whom had come from a local church that had split. Unfortunately, it's discovered too late that these new members had ulterior motives. Their plan had always been to join, become the majority, and then vote to completely change the church's denomination, name, location, staff. They just a hostile takeover, essentially, okay? Now that they are the majority, can they be stopped? Anybody?
If this is the bylaws.
Yeah, yes, if it's in the bylaws, I'll think.
Well, what if they followed the bylaws and now they're the majority?
Because nobody challenged it.
That's the difficulty here. He's now retired, but there's a DOM, or I guess an AMS, down in the central part of the state that coined a term about 5 years ago called steeplejacking. Kind of like carjacking, but steeplejacking. It's this scenario. It's perfectly legal. If most Southern Baptist churches are basically democratically, congregationally led, okay, so even the staff-led churches that have congregational votes are still democratic in nature. So once the majority becomes the majority, or the outside group became the majority, that's essentially their church. If they have the votes, they can do what they want. Okay, there are some protections we can put in place, and we can talk about that. But this is a real concern for a lot of Southern Baptist churches. That is, I'm a believer in the doctrine of local church autonomy. Everybody's familiar with that. It's a fundamental tenet of Baptist denominational faith and theology. This is one of the weaknesses of that. You are an individual, isolated entity out there, and somebody can come in and exploit your own bylaws to take you over. Okay, and that's legal, not moral or ethical, but it is legal. Okay. All right. What's about a question of who is a member? Do members with more seniority have more say in what happens? Not legally. Effectively, maybe, but not legally. Okay, a member of one day has the exact same vote as a member of 100 years. Okay, is there a minimum time that somebody has to be a member before they can decide what happens to the church? Unless your bylaws create that, the answer is no. Once you're a member, really, membership in a Baptist church is tantamount to ownership. Okay, you are essentially, in legal terms, similar to a shareholder in a secular corporation. You have a right to vote and a right to say what happens to that corporation. In church, it's very, very similar. I mean, we could dither about the details, but essentially that's what you are. What about members who left long ago? Do they have voting rights? If they still appear on the roll, yes, sir, yes, ma'am. Okay. How many of you have done any sort of purging or sunsetting or reconciliation of your roles as churches? Good. I almost never see that. I'm seeing it more now. But we as Baptists are not known for wanting or liking to reduce our numbers. And that's a necessary part of keeping your roles accurate. And that's an important thing. A lot of churches love to have their roles be as large as possible. And you'll find very many churches that have literally dead people still on the rolls. So if they... Almost always. So sometimes it's by a factor of 2 and 3. Okay, so that's something to think about. All right. Pastor wants to walk the church through a certain non-traditional curriculum. Many members don't. The dispute erupts into a huge mess, which ultimately leads to a vote to fire the pastor over this. The vote is held, and 128 vote to keep the pastor, and 136 vote to fire. It's clear that at least 20 people who had not attended the church for over a year came back just to vote on this. They had nothing better to do on a Sunday night, so they came in to vote. All right? Can the pastor exclude those 20? As long as they're still on the roll, unless you have some sort of provision that removes them from membership, or because a lot of churches just can't remove folks, but you can just say, well, you're a non-voting member. Still a member, just not voting if you haven't attended in a certain amount of time. I've actually seen situations where people hadn't darkened the door for 10, 15 years, but their family had, and their family said, hey, we need the vote to come back. You're still on the roll. So something to think about there. A little bit more information about that situation. 30 of the votes against the pastor were cast by members of the youth group, all of whom were less than 18 years old. Members, but minors. Are those 30 votes valid? Do they get counted? Okay. So in your situation, if they were less than 18, they don't count. Okay. Anybody else have a age threshold? Good. When I started doing this almost 20 years ago, I almost never saw that. And I'm very happy to say that I'm seeing it more often. Now, there's no magic age. It can be 16. It can be 18. Frankly, I know some 25-year-olds that aren't mature enough to vote, but going above 18 causes some issues. So the most common is either 16 or 18 to vote. I would also mention you may want to consider, those of you that have them or are thinking about putting in age thresholds, also for elected office. Because theoretically, unless you create a minimum age for elected office, Sweet Sally, who joins the church at 5 years old, could theoretically be voted your church treasurer. Okay? Legally, all right? And we all know it wouldn't be Sally, it'd be Sally's mom or dad that wanted, but you know what I mean, okay? So just something to think about there. Next hypothetical, one of the church's paid childcare workers, who is single, announces that she is with child. Being pregnant out of wedlock is not the kind of example the church wishes for its staff to portray. However, pregnancy is a covered disability under Title VII and the Florida Civil Rights Act. Can the church terminate the employee without creating a real risk of liability for illegal discrimination? Got some no's. Anybody say, yeah, they can do it? Somebody raise their hand and say, yes, they can do it. Well, the answer is actually both, depending on how you do it. And this is something if I say it once a week, I say it 10 times a week to churches that call me. How you do something is every bit as important as what you do. You can be right biblically and legally, but be wrong if you do it in the wrong way. This is just one of many examples. This is actually a real scenario. Actually, there's two scenarios. They were mirror image scenarios. You had a preschool worker who got pregnant as a single woman. One was in Ohio, one was in Virginia, I believe. I think that was. And they both sued for discrimination. Okay? One church got it dismissed based on the separation of church and state. One church lost big, like 6 figures, 7 figures big. Okay? Same fact pattern. You know the only difference? The one that lost fired her from becoming pregnant. Only women can become pregnant, not men. And so the judge said, look, I get your religious beliefs, but you fired her for a discriminatory reason that only women can get pregnant, and that I just can't let that stand. So she made it through and got a pretty big financial judgment. The other one, where the judge dismissed it before it even made it to trial, the church fired her for having premarital sex. Pregnancy was simply just the evidence of that act, which they deemed to be not acceptable for someone in her position. And obviously it takes two to tango, and that's not discriminatory. Same facts, same result, except one won a judgment for discrimination and one survived. It's just, I bring that up to say there are multiple ways to do almost everything. It's always important, especially when you're treading in areas that are legally fraught, that you know, that you explore all the ways to make sure that you don't leave your church vulnerable. Because both of them did the same thing, but one got penalized and one walked away with zero penalty whatsoever. Any questions about that? Because that's a huge issue.
No, but the issue with Florida, can't we terminate? No, I mean, not just in generally speaking, you terminate an employee without giving reasons.
Yeah, we are an at-will state, so you can fire someone for any reason or no reason, as long as it's not an illegal reason. And it's that last phrase that got that one church in trouble, even though they weren't in Florida. But you can, no reason or any reason, as long as the reason isn't illegal or discriminatory. Okay? So you come in and I say, I hate that color brown. You're fired. I'm not going to have employees wearing that color shoe. That's a dumb thing to do, but it's perfectly legal. Okay? But if you come in and I say, I'm firing you because you're a dude. I don't feel it today. I don't like dudes. Well, that's gender discrimination. Okay? And so that, even in Florida, one of those is perfectly legal, although stupid. The other one is illegal because I just discriminated against you based on your sex and gender. Make sense? Okay. Thank you for the question. That was good.
I'm sorry. Yes, I was gonna have, like, if somebody comes in, maybe with the culture right now, everything's rolling along. I'm a girl, a lady that's helping in preschool.
Mm-hmm.
All of a sudden, all right, now I changed my identity.
Mm.
You know, that's a little. I mean, obviously, that's not what you want in there.
No.
Did you?
That's a great question. And right now, who knows what tomorrow will bring? Who knows what November will bring? Okay. But right now, churches still maintain the right to make employment decisions based on otherwise discriminatory employment decisions based on theology and doctrine. If it's a good faith, sincerely held religious belief, churches have the legal right to discriminate in hiring, discipline, and firing. Okay, so if you hired someone and she came in and she was a model employee, then she decided that she was going to be a he, well, that's against what most Southern Baptists believe. And so then, yeah, you have the right to make that decision. Now, having the right to make it legally and how it's done, but also just you need to understand in today's society, you are going to get blowback. It may be the right thing. I'm as a lawyer, I never tell people to make decisions because of what might happen, but you need to be aware of what's going to happen. You're going to get, the community is going to throw shade all over you. You might even get hit with a lawsuit. You'll have to defend it, and you probably will win it. It will be a difficult time, but you legally have the right to do that. Yeah. Mm-hmm. Yeah.
Could you just say your documents, a man shall be considered a man in the biblical sense?
Yes. I'm a big believer. In fact, we've got some slides on that about later. It's very important that you have a statement of faith, articles of faith, something in your governing documents that clearly identify, here's what we believe. Okay. Now, I differ with some practitioners about some other things, and we'll talk about that in a minute, but the answer to your question is yes. All right. If you don't mind, I'm going to skip that one for the sake of time. Let's see. And that one. Keep in mind, you'll have these and by the way, at the end of this, the last slide is my cell phone and my email address. So if in some of these hypotheticals that I skipped over, you want to talk to me about it, just shoot me an email and say, hey, look, I had a question about one of those things you skipped over. Okay. All right. These are 7 important Constitution and bylaw provisions that you need to make clear in your governing documents. One is the very first one, statement of faith. That's what you just talked about. That is just one of several things. You can create your own statement of faith. You can incorporate another statement of faith by reference. We have one at our fingertips that's pretty decent, the Baptist Faith and Message. That was last drafted in the year 2000. I've heard rumblings they're thinking about doing an updated one. Don't know that for a fact. But the one done in 2000 is pretty good. The only thing it doesn't specifically address is transgenderism, but it does talk about the Genesis passage that men and women were created male or female. So it tangentially addresses that one as well. So you don't necessarily need to restate it in your bylaws, but if you don't have your own statement of faith, that would be an easy way to handle it. Okay. Definition of membership rights. The hypothetical kind of highlighted the importance of that. You want to have that in there. There's some slides that are going to explain all these. Sorry, back up. The process of becoming and ceasing to be a member. We're really typically pretty good about the becoming a member part. We're typically fairly bad about the ceasing to be a member part. Okay, so we need to address both those things in our bylaws.
Quick question.
Yeah.
We had a lady call up, and she one time over to the church. I don't know, she got a thing or something, but she said, I wish to be removed from the membership of Highland Baptist Church.
Awesome.
So her husband is a member, but I think they put her an inactive member, but they never erased her out of the membership, and so she stayed. I think she sent a letter as well. So
Yeah, I would. I'm a big believer. If someone wants to remove themselves, let them. Okay, because typically they're not happy, and they're going to become a problem if you don't let them. And so they've just removed themselves. Now they have no legal right to be there. Now they're just an attender. And members of the public, even though churches allow the public to come in, they are still private property. They are not places of public accommodation. So if a problem person removes themselves from membership, she has done you a huge favor. Because otherwise, a person that's stowing up strife and discord is subject to church discipline. And that's a tough, difficult, long process in most Baptist churches. So yeah, thank you very much. Good luck down the street. Godspeed. That'd be my recommendation. Strong recommendation.
And walked in one day to the secretary, like the church, he walked in and said, I want my letter. I'm leaving.
Oh,
So she typed him up a letter that says, this is a letter saying he left our church.
there you go. Well, in days gone by, that was more of a thing than it is now. It's very rare that churches even seek out letters of from somebody joins a church by letter. I mean, the transfer of letters is almost non-existent anymore, but that's probably what he was referring to. Yeah. I want my letter. Yeah.
But they're talking about when we don't get those letters, that hurts that well. It makes it harder to clean up our rolls and such, because there's folks that we know are at other churches. Well, they're still very well, but they've been attending that church for 45 years.
Yeah. So, well, let's go ahead and talk about it. I've got a slide about that, but since you bring it up, let's just talk about it now. There are multiple ways to deal with the ending of membership. Okay, one is you request it. Okay, the other is death. That needs to be in your body. If they die, they are no longer members. The other one is, and this is really common actually in older bylaws. If they join a church of another denomination, it's automatic. But that leaves open that loophole of, well, they just went down the street and joined the Baptist church down the street. So you're okay with dual membership? Most churches aren't, but their bylaws allow for it implicitly. And so I encourage churches to clean that up and say, if you actively go and join another church, that's an automatic revocation of your membership here. The only time that wouldn't work is if you have a big snowbird population. But even in that situation, you can not be, like I said before, it doesn't have to be all or nothing. It could be your voting rights go where you join, but you can still be an attender, a non-voting member here. That's up to you. But some clear statement of these are the criteria, or these are the triggering events that cause you to lose your membership. One of them can be attendance. A lot of churches are moving to this, that you have to at least financially participate. It's some, because you can't really say tithe, because that brings in CPAs to all this. You don't know what 10% is. But some financial participation and attendance within a certain period of time. Some churches it's 6 months, some churches it's a year. But we have to have seen you once in this period of time, or we may contact you and say, hey, do you still want to be a member? Okay, that's another way to do it. The difficulty is whatever you choose needs to be empirically provable. Okay, we as Baptists, we're not Presbyterian, so we don't pass the roll down the pew in the worship service. They do, and they could use that as an attendance. We don't do that. There is one place that we do a good job, however, of taking attendance, and that's Sunday school, small groups. Okay, so some churches have used that. I just say that is whatever metric you use needs to be provable. Otherwise, it's just, well, yeah, I was there this year. Well, no, you weren't. Well, how do you prove they weren't? You see what I'm saying? So it needs to be some metric that you can establish. These are the other four things that really need to be in your bylaws. Voting thresholds for certain things doesn't have to be the same. Okay, my preferred methodology is unless and until we say otherwise, it's just simple majority. Okay. And then you say otherwise for things like selling, buying, hiring, firing, things like that can have higher thresholds for voting, but that needs to be discussed. A discussion of quorum. If you say nothing of quorum, Robert's rules, the default rule is whoever shows up. So you can have a meeting of one and pass a budget. Okay, there are upsides to that, but there are also much potential downsides to that. So just discuss quorum. Designated gifts we need to talk about. Everybody know what designated gifts are? Gifts with strings attached to it. If you accept a gift with strings attached, can you change the nature of that gift at any time in the future? Only if you get permission. Exactly. Without that permission, which gets difficult if it's someone who's no longer with us. Okay. And so I encourage the use of a provision that will accept designated gifts, but also if they are designating something to a ministry or an account that doesn't exist, that it's discretionary. As long as it's in your bylaws and you inform them that their designation may or may not be mandatory, the IRS is okay with that. Okay, the IRS is what we're really concerned about, them coming in and tagging you for some high dollar violation of the IRS regulations. The designated gifts? It depends on the nature of the gift. Shouldn't be, no. But each gift may or may, depending on the size of the gift and the nature of the gift, you may or may not want it in its own account. It might be a building fund where you have hundreds of designated gifts that are aggregated into that building fund account. But yeah, it would be a separate account for that purpose. Yeah. Mm-hmm. Depending on the size, sometimes it's line items in your budget. Okay. And so it's less important where the money is held and more important how the money is used. Okay. Some churches find it easier to keep a separate account or general account and a amalgamated designated gift account. And so all your designated gifts, regardless of the designation, are in one account. There are multiple ways to do it. Yeah. Mm-hmm. Yeah. Yes.
Let's just say that you're voting on an issue that got for a reason. And the church is divided over it, and you vote, and there is a majority. And it's a small majority, but as a pastor, I would feel very reluctant to move forward with that. It's church split over. It might even, consider, well, let's take time and pray through this.
Mm-hmm.
If somebody wanted to make an issue of that, would there be any legal ramifications for that sense?
Theoretically, yeah. That's why it's important to decide ahead of time what issues are we going to require a higher threshold for. Okay. Yeah. In that situation you just mentioned, if you as pastor said, I know it technically passed, but we're not going to do it because it didn't pass by enough, and your bylaws were clear, all it required was a simple majority, someone could claim that you've improperly squelched the will of the members and legally take action. Okay. That's why things that are potentially church splitting type things, those are the things you consider just having a minimum threshold, which is more than simple. Okay. That's 2/3, 3/4. I would never go in Baptist life. I wouldn't go beyond 3/4 because good luck getting a unanimous Baptist church on anything. But yeah.
Would you provide notice that you have to provide notice to all standing members that you have on the ropes, whether they attended church or not?
That depends on your bylaws. Some churches don't require affirmative notice going out of the walls. Most churches have some sort of notice requirement for certain things like bylaw amendments. Usually there is an express requirement that you provide notice, but sometimes it can be just from the pulpit 2 weeks in advance or 1 week in advance. Some churches do have a newsletter or a requirement that an email is sent, but you're in control of that when you're writing your bylaws as far as the notice provision. There's no state law that requires all the members be mailed out something that, hey, you've got a meeting coming up. That's purely a bylaw thing.
Bylaw that says 3/4 of the members of the church.
Mm-hmm.
You then would have to give notice to all the.
Because as long as the practice is it's understood, but whenever I'm drafting, I make sure it's clear all the members present and voting. Okay, so it's not 3/4 of the membership roll; it's 3/4 of those that showed up and cast a vote. Because you might have some that show up and don't cast a vote, and so those don't even figure into the calculation. Okay, so that should be that the threshold we're talking about should be the percentage of those who showed up and voted, not the totality of the membership. Because as we all know, the percentage of the members who actually show up to a business meeting is a pretty small percentage.
But if you wanted to change something like a constitution,
Mm-hmm.
and it says 3/4 of the members of the church, you're just saying 3/4 of the members.
I'm hopeful that it says 3/4 of those present and voting, okay, or other verbiage that it requires a 3/4 majority vote, supermajority. Well, that implicit in that is you have to be there to vote, okay? Frankly, there are some churches that allow proxy voting. I'm not a fan of it, but in that case, then you would include the proxies as well. But I've never seen a church Yeah, that's true. I've never seen a church that required it be 3/4 of the membership rolls. That would be a threshold you probably would never achieve.
But that's all the more reason to keep the membership rules.
Yes, sir. Yes, sir. Mm-hmm.
But
Mm-hmm.
that kind of in Robert's rule, but you're having an item on the floor. There's kind of a hearty discussion. As the moderator, you feel like there's still people that want to hear their voice, and then maybe somebody that just wants to jump in and say, "I call the question." I make a motion to call the question.
Yeah.
Can you rule that person out of order if you feel like there's more?
Okay, I'm not a parliamentarian. I didn't even stay at Holiday Express last night. But my understanding is unless there's some reason it's out of order besides there are other people still around, then no. If he's got because I think that requires a second, doesn't it? Yeah. So as long as he makes the motion and there's a second, I think Roberts allows for that. But I would defer to folks like Craig Colbreth. They would know. I would reach out to him. Don't rely when it comes to parliamentary procedure. Don't rely on me. Yes, the enforcer. That's right. Okay, and then lastly, this is something relatively new, but is a hugely important tool, a policy regarding the use of facilities and assets. This is where we can define some protection against those that want to use our facilities in ways that are inconsistent with what we believe and teach, a la gay marriage, or I'm getting a divorce party, or something that are real things that churches are being asked to use their facilities to do that we don't believe. So, all right. Man, that goes so fast. Okay. Some discussion of the statements of faith. We already did discuss some, so we won't spend a lot of time here. The key, though, is we need to have some statement of faith. It doesn't have to be the Baptist Faith and Message. It can be your church historically came up with its own set articles of faith or its own, we're not a creedal people, but you know what I mean. Something that describes what we believe. When I'm drafting them, the first sentence is always, we believe in the Holy Scriptures. That's the touchstone for everything. And then the Baptist Faith and Message, or here our statement of faith that summarize some of our beliefs, but you install the Bible as the touchstone. If there's any doubt what the Bible says, and here's how we interpret the Bible, okay? Like I said, the Baptist Faith and Message is one we can use. If you don't have one, like I said before, incorporation by reference is a great way to save space, because even the Baptist Faith and Message, that takes up 5-6 pages in your bylaws or your Constitution. And so you can put it there if you want. You can just have a reference to it. You can include it as an appendix. All those are possible ways to do it, but having something in there will put you in a great place if and when you get challenged, especially with the asset and facilities use policy. That refers directly back to your statement of faith. Okay, so those work in tandem. That's why it's important that you have both. All right, defining membership. We've already talked about just in general. Couple things. How many of you, I'm a PK, okay, dad's church growing up, always had an invitation, and people come down and want to join. All those in favor of Billy and Sue becoming members, say amen. Amen. They were members. We don't know Billy and we don't know Sue, but they're now legally members of the church. That's a dangerous practice, and it is a traditional practice in Baptist life. I'm not suggesting we change how we conduct services. All I suggest is you don't officially vote on membership right then. All those who are happy that Billy and Sue came down, say amen, clap, whatever you want to do. Thereafter, you have a new membership class, new membership orientation, some way where you get to vet them, they get to vet you. They get to understand who you are and what you believe as a church. And then assuming they make it through that and there are no problems, they're not witches or warlocks and not Satanists, and they really are Bible-believing Baptists, well then, next business meeting, you vote on all those people that they expressed an interest in becoming members, and we were happy about that. But now we're voting on them because they've been through that process. They're eligible, and then we vote on them at the next business meeting. Everybody get that? Okay, and that's becoming more common, but it is not the traditional practice of most Baptist churches. And the traditional practice is dangerous because, like I said before, once you vote on them and they are now members, they're now members. And they have equal say to everybody else in the church, even though they've been members for 2 seconds. Okay? All right. And then the last thing is the member for life, no matter what, is dangerous. And frankly, as a PK, I'm not sure it's biblical. Okay, there should be privileges of membership, but there should also be obligations of membership, service, doctrinal fidelity, other things. Okay, so you need to have provisions in your bylaws that deal with, okay, how does someone cease to be a member? It could be discipline in some situations. It could be the request that we talked about earlier. It could be a number of things. Okay, let me ask this, and this is not on the slides, but let's say you start church discipline with someone because they're having an affair, and they refuse to repent. They refuse to stop. You start discipline, but then they withdraw their membership. Do you let them go and stop the discipline, or do you press forward with the discipline? Any thoughts?
I would let them go. We have an obligation to, guide them and restore that.
Mm-hmm. If they become repentant, because keep in mind, in this situation, they're not repentant. Right. Even with the withdrawal, they were very much adamant, I'm going to stay in my adulterous relationship. Right. I know it's kind of a no-win question I'm asking, but let me give you the reason I'm telling you this. A church in Jacksonville went through this about 12, 13 years ago. The person, it was a female actually, who was unrepentant in her adulterous affair. She sued them for a number of things, including intentional infliction of emotional distress. And she won. And the judge said, look, she left. She withdrew. You had no further legal need to take action. The discipline process, the ultimate end of the discipline process was termination of membership. She withdrew. That was unnecessary. Okay. Now, I can make a very good biblical argument that the purpose of discipline isn't the punishment, it's the restoration up until the very end. The point is not punishment, it's restoration.
But if she's no longer a member,
that's what the judge seized on. Okay. Keep in mind, there's only so much theology you can argue in front of a judge. I've literally had a judge stick his fingers in his ears and say, Mr. Yeldo, stop talking because I can't listen to what you're saying. I knew that, but I was trying. Okay. In that situation, I encourage churches, you don't proceed with a discipline. If they voluntarily withdraw, you honor the withdrawal. No more discipline. For those pastors that think, however, this is still a teaching moment for my church, and they need to understand what the discipline process is about, and there's a reason this happened. That pastor was adamant about it. You can still preach on the issues. Just don't connect that final dot and say names. If to teach on adultery, teach on adultery. Just don't connect that last dot. Everybody in the room is going to know who you're talking about. But as long as you don't say it out of your mouth, legally you're good. Everybody understand that? That actually comes up more often than you might imagine. So I wanted to make sure we were clear. I wanted you to have that information. Okay. We've talked about that. Yes. All right. Thresholds, I think we've covered. Any questions about thresholds? We spent some time talking about that. Okay. Quorum, we talked about that as well. Designated gifts, we also talked about that. So we were good. I referenced this, but I didn't talk about it. So we're going to talk about it. This is the provision I mentioned earlier about protecting you from improper use of your facilities. Okay. You tie it directly to your statement of faith, so it is a purely doctrinal and theological thing. Okay. The fact that you have it in your bylaws is a great tool. Without this in your bylaws, you still have the same course of action available to you, but having it in your bylaws is a great tool, so you can say to the people who are requesting the use, say, look, this isn't personal, but legally, I am unable to grant your request. For the reason I talked about at the very beginning of this, that whole legal nullity thing. If you were to violate this for someone, that's a legal nullity, and it can be challenged by one of your members. Okay.
rental, when you talk about
any use, rental or otherwise. Okay. In fact, I'd be cautious as a church renting my space at all, because you want to make sure you preserve that bright line of, because a place where commercial renting occurs is a place of public accommodation. A place where use occurs, there may or may not be money that changes hands for that, preserves the fact that you are not a place of public accommodation. That term you've heard me say several times is crucial here, because there is a litany of cases that say that places of public accommodation are in the stream of commerce. Therefore, the federal and then backdooring the state can tell you what you can and can't do.
To rent a facility which is no longer used.
Yes. To the public. It may, depending on the nature of the rental. So whenever churches call me about that situation, I don't like to use leases or rental agreements. I use of space agreements, okay? And the amount they charge for that use is at least 50% lower or more than retail rate in your community. If retail rate's $10 a square foot, the church better be at 5 or less.
Is that income related?
It can be. That's a CPA question, but you bid an unrelated business income tax can be an issue. The closer you get to retail rate, the more almost certain it would be, and you run the risk, see the pastorium situation of losing the tax exempt nature of that little portion of your property.
And such would be true also in your rentals. Appraisal value.
It could be, depending on where you are in the state. This part of the state isn't quite as hostile to churches as South Florida is, but the further south you go, the more likely a taxing authority is going to try to come in and claw back some of that missed taxes that they think they're missing out on. Good question.
Quick question about building use. What about ADA accommodations? Are we?
That is a quagmire. Potentially. Okay. A lot of our buildings are so old, we're grandfathered in. Okay. Depending on where you are in the state, however, like for example, Miami-Dade, they have that 40-year certification process. Every 40 years, every building has to be brought up to today's code. That is the exception, not the rule. But depending on where you are in the state, you need to understand, is there a window within which I have to get up to code? Or more likely over here, are there certain renovations or repairs or additions that will subject me to a code that otherwise I wasn't subjected to? I always encourage folks to try to be semi-friendly with their local, the property appraiser's office and the building code people, so you can call them and ask, hypothetically, if a church were to do this, and that way you don't get in a situation where you got too far down the road in the project and all of a sudden that $10,000 repair project is now a $100,000 code there. Yeah, that's right. Good question. All right. Okay. Any questions about what we talked about? Because that's the end of that particular bylaw section. No questions?
We got into a situation. We found out our usage policy was violating against our insurance. They said that we couldn't allow anybody that was not a member of our church to have control, care, control, and custody of our property. That we have to have somebody there for anything we do.
To oversee it, or are they? Yeah. Well, frankly, that's not a bad policy to have anyway. Yeah. You can blame the insurance company for something you wanted to do anyway. I get blamed all the time, and I'm fine with it. But yeah, that happens. One thing I didn't mention before, I alluded to it. There are some folks that disagree with me as far as the asset and facilities use policy as the best way to handle like same-sex marriage and other things. They suggest having an anti-gay marriage provision, an express anti-gay marriage provision in your bylaws, or anti-transgenderism, or pick a current hot button topic. Perfectly legal, like we said before. At least right now, we have the legal ability to discriminate based on our religious belief. Nothing illegal about it. I just don't think it's a good idea strategically, because you're not creating any legal rights you don't currently have, especially if you put that in place, the asset and facilities use paradigm in place. You've already covered the waterfront, and you're singling out certain groups, certain sins, and elevating them to a super sin category, for lack of a better term. Doctrinally, I think it's an issue, but legally it's an issue, is because I'm telling you, if I believed in crystal balls and had one, when the separation of church and state when that's going to be attacked is in a situation like that, where you're singling out one group more than another. And those kinds of provisions are just giving them the ammunition. And you don't have to. Okay, so I just wanted you to be aware. There are people that disagree with me as far as using that as a overarching protectionary tool, but there are reasons why. I make no bones about it. I think you can do the other. I just think it's strategically a bad idea. Any questions about that? No? Okay. We'll spend a little... Yeah, we'll talk about this for a couple of minutes, and then the rest you can just review on your own when you get it in email. These are some areas where we're weak about. We don't have enough time to talk about sexual abuse in the church in general, but here are just some areas where we are typically weak, and through which oftentimes bad situations come in. When we're counseling or mentoring, okay, how many of you pastors in the room? One? Okay, all right. How many of you do pastoral counseling? Okay, but some. Okay. I'm a fan. Okay, so I'm not attacking that, but we need to know as pastors when it's time to pass the ball off to somebody else. If they have serious mental health issues, somebody that needs clinical counseling and not pastoral counseling, that is oftentimes where problems. When we refuse to hand the ball off, we get ourselves in trouble. Okay, that's one area. Other areas, gender issues. I mean, this is navigating gender in our society now is so hard. Used to, as long as you're male, obviously, and you're counseling a male, no problem, right? That's not the case anymore. You've got to be careful. Female counselors, you are vulnerable to accusations. I can't tell you how many times pastor didn't do anything wrong, but he's been accused of something, and it was just him and the person in the room. Okay, so you don't necessarily have to stop one-on-one counseling, but we have to be very intentional about we do it in a way that can be seen by outsiders, either at a public place or behind glass, so people can see that bad things aren't happening. Okay, they can't hear, but they can see. Having video cameras, they're super cheap now. Okay, you can get them and just turn the audio off. So there's an expectation of privacy that's preserved as far as what's being said, but having a record of what didn't occur when you're doing one-on-one counseling, regardless of the gender, is a big deal. Okay, and I'm looking at you because you're right in front of me. I'm not singling you out. It could be anybody in the room.
Is there a legal issue of even recording the
video? Audio, yeah. Well, it's not so much a legal issue, but you definitely want to have their permission. You regard video and audio. But I can say, as someone who comes from a family of pastors and counselors, a lot of counselees wouldn't want it recorded. You know,
like this day and time, even a conversation, even if they can't hear what's being said, well, he was trying to get me to whatever.
Right. Yeah. They would have to agree, and you want to have that agreement in writing, because in Florida, to record someone surreptitiously without their knowledge or approval is actually a crime.
Her lady, she called yesterday and asked, could she maybe use a Sunday school room in our church to meet with her family advocate.
Mm-hmm. Mm-hmm.
When I've carried them to the area of the church today, I said, which I know.
Yeah.
It's a good ways from them, but there is a camera view or.
That's good. Yeah. And because technically in the church, your right not to be recorded, whether audio or video, is based on a reasonable expectation of privacy. Except for bathrooms, changing areas, things like that. In a church, there's no reasonable expectation of visual privacy. You can argue there might be one of audio privacy, but the fact that you told them they're on camera, I recommend that. That's the better course of action. But even if you hadn't, I would argue that there's no reasonable expectation of privacy in a room, in a room that you don't own, in a place where other people can come and go. Okay, hallways, main rooms like this, because you're being videoed tonight. You didn't sign any waiver when you came in. So, all right. Age issues about this is crucial. Okay, everybody understand the priest penitent confidentiality. That's a statutory provision in Florida. If you are a member of the clergy, ordained or not, there is a privilege that attaches to communications of a counseling nature when you're providing pastoral care. And who owns that privilege? Everybody understand this? You've got someone, your pastor, someone talks to you, tells you something in confidence, or even not, it's just counseling. There is confidentiality that attaches. Who owns that? The person does, right? Not you. You can't waive that, okay? It's no different if it's a minor, okay? What you need to be, because of that, it's important that when you're doing counseling of minors, and this is really true with your workers, like youth workers, youth leaders, they need to not promise something they can't follow through with, because they may hear some things in youth counseling that triggers the mandatory reporting statute. And the mandatory reporting statute makes it clear that it trumps the pre-specified confidentiality. That can't be used as a reason not to report. So they need to be aware that if they ask, even if they don't ask, if they're talking about sensitive things, they need to be instructed to tell that youth that, look, yes, this is a private, confidential conversation within the bounds of the law. There may be some things you share I have to share. And that's important for you to clarify, because you don't want to be on the horns of that dilemma that you promised complete confidentiality, but the law requires you to breach that. Okay? Everybody understand that?
Where can we go to get what those guidelines are?
What, the mandatory reporting guidelines? It's chapter 39. I should have that memorized. Oh yeah, if you just type in Florida mandatory reporting statute, it'll pop right up. It's chapter 39. I'm almost positive. I think it's 3905, but it's in there. They've done some tweaking to it in the past years. Used to be it was only applicable if there was an adult involved, but about 4 years ago, with remarkably no fanfare, they changed it and expanded it. So now it can be minor on minor abuse if there is some sort of power imbalance, some sort of inequity involved. So it expanded it. Yeah, if you're a senior citizen, if you're over a certain age, yeah, that's a provision of that law that a lot of times gets forgotten. Yeah. Okay, let me see. Yeah. All right. Like I said, I will make sure Brian gets this and you can get a copy from him. Any questions at all? In fact, let me get to the last one so you've got my email and my cell phone. You can text me. Let's see, get there. And there's a few things that we didn't get to. All right. Cell phone and my email. You're welcome to use either one. So with that on the screen, any questions while we wrap up? Things that I didn't talk about that you hoped I would have gotten to, or things I mentioned that you're not quite clear on? Yeah.
Once a situation and it's something that could have been mandatory before a kid started to tell me something. Backed out. Can you yell so? That's what I did find to hear about. Student got involved and the parents. So at that point, there was nothing I needed to do, right? Because their parents was involved in correcting the issue.
So it's a very appropriate question. The statute requires action if you know or have reasonable cause to suspect there has been abuse of some type. In your situation, if I understood you correctly, he was in the process of telling you something and never finished.
He didn't tell me the whole story. He never did that. When I finally...
Yeah. And what you did hear was nothing.
It was just, he said, "Did you know what happened?" And I said, "No." And then when he started telling it,
he just stopped. Yeah. Unless he had gotten out enough for you to know or reasonably believe there has been abuse, there was no obligation. That said, could you have called? Sure. But keep in mind, that's a far... that standard is not as easy as it sounds. Okay, because A, are we almost ever going to know? Because how do you know something? You have to see it, right? Unless you see it, you don't know it. If you're told something, you don't know anything except I was told something. That may or may not be true. Okay, that's where the reasonable suspicion comes in. That's a very discretionary standard. Okay, so a lot of pastors call me, and we have to talk about that first before we ever get to what do I do. Is okay, do you know anything, and then what is it reasonable? Because here's the thing: if someone tells me that Dave molested him last Friday, and I know for a fact Dave was in Peru last Friday on a mission trip, that's physically impossible. Dave's a great guy, but he can't molest somebody in Florida and be in Peru at the same time. I don't have reasonable cause to believe or reasonable suspicion of that. That's somebody who just lied to me. Okay, so that is not something I feel obligated to report to anyone. Now, in that situation, what I would do is hand my cell phone to the person who just lied to me and say, you what you've alleged is a crime and is reportable here. I'll support you, but you need to report that and let them hang themselves. More often than not, they're going to, oh no, I don't want to report it, because they're just crying wolf and they're trying to get attention or whatever. But in those situations where you've been concerned about a situation, someone tells you, hey, so-and-so touched me inappropriately, and you've kind of had that feeling, that's reasonable suspicion, and you should call. Yeah, because there is a safety net built into the statute. Even if you're wrong, you can't be held responsible. Okay, so if there's a doubt, you're not sure, it's always safer to go ahead and make the call. Does that make sense? Yeah. Okay, with that, we didn't cover about half of what we had, but if you want to get the rest of the slides from Brian, feel free.